A follow-up question on that to you, Spyros. Maybe any other considerations that or skills that are particularly sought for in an arbitrator sitting in a construction dispute, or any considerations that are different in the process compared to any other non-construction commercial disputes at the stage of the selection?
Thank you, Stella, and thank you to the organizers for having me here. I'm very glad to be part of this very nice conference. So, to your question, I think that engineers and lawyers are equally dangerous in construction arbitrations, and I will explain myself right now. Of course, there are some things that somebody must know or must command in order to be an arbitrator in a construction dispute. He must or she must be technical literate, at least be able to understand some technical issues. I'm referring, for instance, to delay analysis. But in addition to that, one should be able to understand some economical issues as well. Mm-hmm. For instance, the key point in many construction disputes revolves around the question of the change orders. So one must be totally capable of understanding why the change orders build, in many cases, the core of the dispute, and to understand why the constructor bases his claims, or most of them, on this change orders mentality. So the arbitrator must very well know this mentality of the change orders, which brings many cases to the arbitral courts. Of course, another skill would be to be able to manage complex evidence, to cope with huge amounts of documents, massive document production, conflicting expert reports, etc. And in addition to that, one must know that the arbitrator in construction cases must manage the parties as well, the experts as well. They must avoid the critical question on the part of the experts or the parties. Mr. Chairman or Madam Chairman, do you understand, Madam Chair, do you understand exactly what we're talking about here? Which brings us to the next question, to the next skill, which does not belong to the things I have already said, which could be said to be trivial observations. The arbitrator in the construction cases must have the intellectual candor and the courage to face the parties and their experts and to say that she does not understand what they are trying to convey. If the arbitrator is courageous enough and frank enough to go beyond the image of somebody who is supposed to know or to perceive everything in a perfect way, directly in the first approach, and if the arbitrator is not susceptible to the pattern that he must know everything, and to the temptation to signalize to the parties that he knows everything or she knows everything, and if he avoids to have this stress to demonstrate that she or he is in command of the complexity of the case, if she has not the burden to show that they have understood directly the case, then we are in a very good way. We are showing to the parties that the arbitral tribunal are not the best place to present their dispute. And then the parties, in most cases, understand that the tribunal will not be in the position to exactly have the insight that they themselves have. This brings many disputes to a settlement before an arbitral award. If they understand, if they get the insight or the suspicion that the arbitral tribunal will not understand the case as good as they do themselves, because they know. The parties know, for the most part. And if they know that this is going to be an obscure thing, a black box, with no foreseeable award, this helps them to help themselves. So the skill I would recommend for an arbitrator in a complex construction case would be to be frank enough and open enough to say to the parties, to tell the parties that she or he does not get the point, that she or he does not get the point even after the first hearing, that they do not exactly manage to convey the message, and to insist on this point so as to let them unravel the case better, to let them deconstruct the case better, simplify the case, and make it even simpler for the arbitral tribunal to find an award, to find a decision. And this is the thing I would like to insist on, instead of repeating self-evident observations like, okay, he must know or she must know something from technical issues, etc.